Hamilton Road, LTD versus Claude Miller and Betty Miller. File number is 23-01344LT. Can I have appearances, please?
Good afternoon, Your Honor. Gene Turnwald, on behalf of Hamilton Road, a representative is seated in the courtroom.
Good afternoon, Your Honor. Darwin Fair on behalf of all the defendants.
Okay, well, this set for multiple things. Let's see, there's a motion. It doesn't make it clear what the motion is for, and then there's an objection. I'm assuming the objection is to the motion. There's a motion to strike filings by non-party Betty Miller for writ to issue and for sanctions.
That's correct.
Okay, and then there was a defendant's motion for reconsideration, which I set for an in-person hearing. There was a Betty Miller who filed in pro per. Is Betty Miller here?
She's downstairs. She can't come upstairs. She has panic attacks and she don't right now. She'll freak out. I'm her son.
Is she in a wheelchair?
No, she's not in a wheelchair.
Oh, we have a stairwell.
She climbed your stairwell back in January, I think it was, and almost passed out.
Okay. Well, she's filed this motion to the court, and then I'm assuming she's going to try to appear, I would imagine, in the circuit court or the Court of Appeals, wherever else this case may land. How's she going to get there? Because I can't proceed without her, and her son can't represent her in court.
Right.
Your Honor, if I may, Your Honor, if I may, those.
Oh, Mr. Wait a minute. Everybody doesn't get to decide when they may. I'll decide who mays on today. I don't have an appearance from you, Mr. Fair, on her behalf. She filed multiple things since my judgment in pro per.
Your Honor.
Counsel.
It's our position Betty Miller is not a party, never was a party to these proceedings. The court is being intentionally misled by Mr. Fair. The file in this matter happened on January 31st. This court awarded possession to Hamilton Road based in part because the occupants were not the same as the plaintiffs in the Court of Appeals case. Since then, a number of filings have happened that are Betty Miller in pro per. Betty Miller never was a party. Only Claude Miller and all occupants. There was no summons, no complaint ever issued to Betty Miller. She was never added as a party, not once. However, the Court of Appeals case, which is also ironically drafted in pro per, has Betty Miller as a party. So there's a unique advantage adding her as a party after a trial to mislead the circuit court judge. Now, I'd like to back up a little bit. And Your Honor, I know you know a lot of the history of the case already.
I'm sorry, let me stop you. Who are you?
Daryl Davis. Yeah.
Okay, you can have a seat because I'm dealing with the matter versus Betty Miller at this point that I ordered in person. And you can have a seat too, sir. You can proceed.
Yeah, I'd like to back up and run you through some of this again, just to refresh your recollection. This is a foreclosure. This was an action for possession of a property only that was foreclosed. No payments were made over a year or two. On the very last day, one of the parties contacted my client and asked for a redemption amount. My client stated to them, the redemption period expires today. You're asking to close someday in the future. You don't have enough time. No escrow, no funds were ever deposited. With the plaintiff Hamilton Road or with the Register of Deeds. Redemption funds now are approximately $128,000 or $130,000. We filed a motion to gain the premises on May 1st. On May 21st, and I'm sorry, on June 21st, the defendants represented by Attorney Fair filed a motion to stay the proceedings and also filed in pro per in circuit court a quiet title action claiming that the estate of Betty Miller, Matthew Brown, and a corporation,
The estate of Claude Miller.
the estate of Claude Miller, were the actual owners of the property and not Hamilton Road. That was all done in pro per, but I suspect Attorney Fair drafted. I suspect this because we've located very similar cases in the Court of Appeals where Attorney Fair has argued and lost the identical issues. Bryan versus Chase Bank, for example. You can't make a case where you haven't made an effort to pay the redemption funds of $200,000, whatever they have to be, $120,000, and claim somehow you have standing. You don't. You have to pay it either to the plaintiff, Hamilton Road, or the Register of Deeds. And he's argued these cases in the Court of Appeals, and he's lost. So we have Betty Miller's name on a Court of Appeals case. It was in circuit court, and it was summarily dismissed, identical issue, and they appealed the next day to filed a brief the next day and appealed it to the circuit court. When that hearing finally happens, after it, Hamilton Road is going to ask for sanctions for vexatious pleadings, because it's our opinion, all this is done for delay. Now here in this case, Mr. Fair originally represented that the defendants in this case were the same parties in the appellate court case. Your Honor discovered on your own, you asked the people to come into court and questioned them and found out that it was the Davises that were the actual occupants of the premises. And Betty Miller has never been a party. We had a trial now on January 31st. After the trial only, for the very first time, Betty Miller started showing up in the caption of the pleadings. And I believe this was done intentionally to muddy the waters so they can argue in front of the circuit court judge that, oh yeah, Betty Miller is now the same party as the Court of Appeals. She's never been a party. She is the only one who has filed an appeal. There is no claim of appeal by the Davises. There is no claim of appeal by the estate of Claude Miller. Only Betty Miller in pro per, but I suspect drafted. I have the motion in order for escrow, and it was drafted by Attorney Fair. And there are several things. We've also filed an objection to the order for escrow. Betty Miller is claiming an escrow, asking for an escrow. She's not a party, asking for only $1,000. The previous escrow order was $1,600. It was first entered in December of last year. It was discussed at trial. Attorney Fair knows exactly what the escrow amount is, yet he put a lower amount on it. I believe he intentionally tried to mislead the court. Right now, there's $5,600 as of today in arrears. That's not mentioned anywhere. So my first motion was we timely objected to this order for escrow. We'd like it to reflect $1,600 per month and the $5,600 in arrears.
You said there are $5,600 in arrears on the escrow order?
On the escrow. Since filing the objection to bond, you have a 10-day window where you can file objective to bond. This is the only matter that's still in this court because Betty Miller, the non-party, has filed an appeal and no one else has. So on the bond for appeal, her name appears in the caption. next to the estate of Claude Miller and all occupants. She doesn't belong to be there.
She told the court she wasn't an occupant.
Well, we never named her as a party, never issued a summons. We'd like her name stricken from the caption so that the circuit court does not get misled by why her name is suddenly showing up in the caption. Because we don't want them arguing, oh yeah, the parties are the same now between the circuit court case and the Court of Appeals case. I've also asked that I've been attorney 33 years. 4 times have I asked for sanctions against an attorney. I believe this court has been intentionally misled by this guy, not once, but several times. And I'm asking for sanctions, if nothing else. You don't have to pay him the Hamilton Road. Pay him to your honor. Uphold the dignity of the court. We shouldn't be here.
Okay. You said your mother's downstairs? Where's downstairs?
In the lobby.
Is it in the lobby? She has a phone?
Yes.
Okay. Did she log in? Because someone is on a shock vote and they're not, I don't know who it is. And I removed them, but they tried to log back in. We don't know who it is.
Okay. Go down there.
Yeah, she needs to log into Zoom. Because she doesn't have an attorney on this. Mr. Fair, who are you here for?
Well, Your Honor, I just want to make clear what cases we had before the court. My understanding was a motion for reconsideration and a motion to strike.
Correct, but they weren't to strike anything that you were on.
Well, okay. Well, we responded to.
I'm trying to understand why you're here. I don't have any recent filings from you.
They were rejected, Your Honor, by the file.
The motion to strike, let's see. We answered the motion to strike, and that is what I thought that I would be arguing today. Also, I could speak to the issue of reconsideration, but Judge, if you don't want me to speak to it, that's fine.
Well, you can't,
But
because you gotta, if you're gonna represent someone, you need to file an appearance, and you can't do what I suspect you're doing, which is try to hide behind the 8 ball and draft motions for someone to file on their own and then show up to court.
Well, no, Judge, I would never try to mislead the court like that.
Do you want?
Okay,
I'm gonna ask her under oath when she gets here if she drafted this.
No, Judge, it has it right here that it was done with the help of a lawyer. I did help her as a lawyer. It has it on the pleadings that must be in the pleadings that the document was drafted with the help of attorney. It has it right there in her motion for reconsideration.
Okay. Primarily, it was drafted with the help of you, correct?
That's correct, Judge.
Okay. Again, I'm not clear as to why in one regard you want me to believe that you represent all the occupants, is what you said, but then you appear when it comes to a representation for her on this matter, because I don't have anything in my file that was filed from you I don't have anything.
Okay, Your Honor, if I may, and I know that this is.
You said it was rejected?
It was.
It looks like your filings were rejected through the My File system, so you likely did not file them appropriately.
Okay, so Judge, let me respond to that. If you saw my response to the motion to strike, I addressed that specifically. What happened is, I don't want you to read me your motion, because this is already a very convoluted case, and I think that it's become more convoluted than it needed to be, because I don't believe that people are being as forthcoming as necessary. I had to order everybody in here and specifically request who lives in this property and who doesn't. This is a landlord-tenant case. We are here to liquidate a property. We're not here to quiet titles. We don't address titles in this court. If you get an order from another court telling us that we can't move our case until that issue is resolved, then we do that. We've not got that in this matter. You're well aware of that, because we've gone through that multiple times. I'm not going to reconsider
that position.
Well, I'm not
This is a
asking.
landlord-tenant action.
Yeah, I'm not asking the court to.
And you've not filed any general civil action against Hamilton Road in the interim to help, in this court at least, to help your client's interest, whoever your client is. I'm not clear. I don't know if you represent Mr. Davis. I'm not sure who you represent. Who do you represent,
Judge,
Mr. Fair?
Judge, if I may, Judge, if I may. We were going to file the motion for reconsideration. We were told that we were, for whatever reason, removed from the case. And we spoke to the clerk and they said it was inadvertent. And so what we did is, as quickly as we could, file the motion for reconsideration under Betty Miller, who is now before the court. But the reality of it, Judge, and not to put form over substance or make a distinction without difference, Betty Miller.
One moment.
Okay.
I have to mute Miss Miller until, if you can stand there. I know her son is there assisting. If you stand by, I'm muting her because you're in the lobby and there's background noise, and it cuts off what Mr. Fair is saying. So I'll let you know when you can unmute her. Okay. Okay, you can proceed, Mr. Fair.
Okay, so the key is, Judge, Betty Miller is the presumptive owner of the subject property. It is her husband who was on title, but she is his wife. So she is the presumptive owner of the property. She is the one who filed the lawsuit I'm the one who filed the lawsuit in circuit court for Betty Miller and the other defendants in that case. Then there was
I understand all of that. I've heard this probably 20 times already. I'm very clear. Did the circuit court grant you the relief you were seeking?
No, they did not. That case is currently before
and
the
so you now are appealing that decision of the circuit court, correct?
Yes.
Okay.
Before
Has any court granted you the relief you were seeking?
What you mean in the circuit court?
You said it's before the Court of Appeals?
Yeah, they have not ruled on the case.
Has any court given you an injunction to prevent any other court from moving until that happened?
Well, you have, Judge, with regards to the district court, when the district court gave possession to the plaintiff, and there was an appeal to the circuit court. And as a result of the appeal, there's an automatic stay to the circuit court. And that is what is in place right now. And that appeal.
My understanding is we're here because of the, was there a bond posted? I thought that there was an issue with the bond being posted.
Well, that is what's before the court now, Judge. That's the motion for reconsideration for the bond.
That's what I thought. There was no bond posted. So you got to post a bond in order to appeal.
Well, Judge, that is what is currently before the court. She's asking the court to reconsider its decision
his motion
for the bond because she does not have the ability to pay. And that's number one. But number two, there's an escrow order that my clients are attempting to comply with. But there's another little twist here, Judge, that I found out yesterday or the day before yesterday, in which the plaintiff sued the tenants at this property and got a default judgment against them for rent. So they're on the one hand has a default judgment against the defendant for rent, and on the other hand, they want escrow for the same property, and it's for the same property. But that aside, she doesn't have the ability to post a bond. The house, is in and of itself is enough to protect the plaintiff. And number two, they can pay the escrow. There's this question of whether it's $1,000 or $1,600. We called the clerk's office. The clerk office said it's $1,000. And I'll tell you why, Judge. The last time we were in court, this whole issue of an order that occurred on the 19th, where there was, obviously misunderstanding on everybody's part. And this court said, well, disregard the order for the 19th. And I think that's why the clerk says the order is still only $1,000 a day, $1,000 a month. Now, if the court wants to change it, I mean, that's fine. But from the clerk's, what they told us is only $1,000 a month. But having said that, Judge, I think the key is that Betty Miller is the presumptive owner of the property. There was this court made a determination that the plaintiff has possession, and so there was an appeal within 10 days. So the court was real clear. If there is an appeal, then the possession is stayed pending the outcome of the appeal, and that appeal is still pending. Only question now is this whole issue of bond, and that's what she wants to argue to the court, that she doesn't have the ability to pay. I would love to argue that, Judge, but we had to file it in pro per because the clerk's office took my name for whatever reason off of the file. And so we had to have them re-put our name back on the file because I've always represented all the defendants in the district court. Now, I don't think I have to necessarily argue this motion for reconsideration because the issue is not really so much me, it's the issue of Betty Miller, and does she have the ability to pay the $5,000, which she does not, but she can tell the court herself that she doesn't have it and ask the court to not have her have to pay the $5,000, to allow her to appeal according to the court rules. The court rules are real clear with that, and then allow her or the whomever these defendants are to pay the escrow. But then that's why I want to point out to the court to be clear that Mr. and Mrs. Davis have been sued for rent for that property. So it's like the plaintiff is double dipping, or it's not electing its remedies. But having said that, Judge, I think the key is that you questioning Miss Miller and asking her if she can pay the $5,000, and if you're going to allow her not to have to pay the $5,000. If she's forced to pay the $5,000, obviously that's a problem for her. But I'll let her speak for herself.
So you've already spoke for her.
Oh, thanks, Judge. But Judge, I just want to make it clear. There's no real misunderstanding here. You have Betty Miller, who sued in the circuit court. That case is before the Michigan Court of Appeals. She is, when you talk about this property in the district court, it's still Betty Miller. She is a presumptive owner of the property. The Davises.
No, we're not dealing with ownership here. We're dealing with possession.
Yes.
We're not dealing with ownership.
Well, no, I get
and
that.
She came to the court and she let us know that she did not reside in the property.
No, I get that, Judge. There's no question she doesn't reside in the property. But if you evict the tenants, she's the one who suffers as a result of the owner. And I hear what the court is saying.
I completely understand your position.
Okay.
You believe that the foreclosure was invalid and she should be the lawful owner of the property. Until the court says that, she doesn't get to act like the lawful owner of the property. You got to get a court to make her the lawful owner. You can't, by virtue of filing lawsuits, make her the lawful owner of a property. And that doesn't stop our eviction until or unless another court, a higher court, stops it. And you've not presented that. There's no court that told us, well, we got to review this issue. Look, you pause what you're doing over there. That never happened. In fact, the circuit court dismissed your claim and you're now appealing it to the circuit court. And so I recognize what your position is, but you've not provided the court with sufficient basis whereby they can stop an eviction matter because you have an unrelated circuit court matter being appealed at the Court of Appeals.
No, Judge. No, that's not the legal basis. The legal basis is the court rules in the district court, which says if the court in the district court.
Yeah, Mr. Ferris,
let me finish. Let me
get it out.
The court rules are real clear. If the court gives possession to the plaintiff, which it did, and then if the defendants appeal to the circuit court, it's an automatic stay, And then there's an
I get that
order
part.
to-
I wasn't
Oh.
talking about that. I was talking about before we
Okay.
got here. I
Yeah,
recognize
okay,
the
I'm sorry.
appeal, and
Yeah,
that's how we got
yeah.
the bond on appeal. They are appealing. I set a bond, and they want me to reconsider the bond, or do they want me to reconsider? Ms. Miller, you can unmute now because I need to ask you since you filed this info first.
Your Honor.
Give me just a moment, please. Can you help her unmute, please? Or do I have to send you a request to unmute? Okay.
Thank you.
Thank you. Ms. Miller, can you hear?
Yeah, I can hear.
Okay, and so you filed a motion for reconsideration?
Yeah.
Okay. You're not sure what you filed?
I was at the court, but I don't know exactly, no.
You
What
don't know
motion was it?
exact-
Okay, what motion was it?
A motion, it says defendant's motion for reconsideration.
Well, yeah, for that, $5,000 you talking about?
Yeah, well, you filed a motion, it says on the 7th of this month, addressing the escrow and then also the $5,000 for the
Okay, well,
surety, a bond for the appeal, correct?
yes.
Okay, and why did you file that motion?
Well, I guess it wasn't doing anything, so I was wondering what was going on about that and why we would have to pay the $5,000.
Okay, well, it was typical that you would need to post a bond for an appeal. I'm not sure why you were addressing the escrow because you don't live in the property, do you?
No.
Okay. And the escrow order was asked to the occupants of the property. Were you aware of that?
Yes, not me.
Okay,
Yes,
so you
he had
weren't-
said, he had told me about it. Yeah.
okay. How did you file this motion?
In the court.
You filed it in person?
I guess I was downtown, yeah.
Well, I'm asking you because you haven't been able to come upstairs. So did you go to the 5th floor to file this?
No.
Okay, so how did you file the motion?
I didn't sign no papers.
I'm sorry?
I went to the one on Kalamazoo Street. I went to the courthouse on Kalamazoo Street.
Okay, but this month,
And
this
that
was
was
filed
on
here.
the first place. I don't remember that one.
You don't remember filing any motion here?
No, I didn't sign no paper here, no.
Oh, okay. Did maybe an attorney file one for you here?
Yes.
Okay. You wanted to address the court?
Your Honor, a claim of appeal was not timely filed. You're being misled on that. The trial in this matter was January 31st. Your Honor signed a judgment landlord tenant on February 16th. We have 10 days from February 16th, according to the court rules, that Mr. Fair wants to argue to file a claim of appeal. They didn't file one. They filed one on February 12th before Your Honor even entered the order. That's entirely improper. It says an appeal from the order must be filed after the order is entered, not 4 days before. And it really comes down to Betty Miller is simply not a party to this proceeding. Why are we adding her to the caption? It is a misdirection. It is intended to confuse the circuit court the same way he has confused Your Honor and myself. So that's what he does, and that's why they're all done in pro per, because ultimately they lose. He's argued the same cases, same issues, Court of Appeals, and lost.
I understand your position, and I've heard his position multiple times. Betty Miller is not an occupant for this landlord tenant. And I've said that multiple times. So I can't accept or continue to accept pleadings and filings from someone who was never a party, an interested party in this. Why, Mr. Fair, whether you help her draft it or not, that's not going to change the fact that she's not an occupant. She's told the court multiple times that she's not an occupant. And this was a possession case against the occupants of the property. This matter is not about of the property.
Judge, I hear the court loud and clear. That's why also Mr. Davis is there also, and he can address this issue of his inability to pay the $5,000.
He's not filed an appeal, nor has he filed a motion to post a bond.
Well,
he's not
Judge,
done any of those things.
Well, first of all, let me say with regards to the appeal there was a supplement to the appeal, so it was timely done, and it was done after the final order. So that appeal is currently before the circuit court. And if the court, you know, I Judge, I believe me, I hear what this court is saying loud and clear. I do. And from our perspective, it's one party. It is one party that is.
I understand your perspective.
Okay,
I don't need to hear anymore. Okay, I'll address the motions. There was a motion to strike the filings by non-party Betty Miller for writ to issue. That motion will be granted. Betty Miller is not a party in this matter, nor was she ever an occupant in this eviction landlord-tenant proceeding. So that motion will be granted. The motion for reconsideration is not properly filed. Betty Miller can't file a motion for reconsideration for the occupant, Mr. Davis, being evicted. If you want to represent her or help her improper to file a motion or a action in another court to stay this eviction pending her court of appeals, that's different. But you can't attach her to this matter the way you've been doing it. It's improper. I'm tired of the filings. I'm tired of the back and forth. I'm tired of having to find out who lives in the property, who doesn't. I don't want to see this case anymore, to be quite honest with you. I'm not going to sanction you at this time, but I can guarantee you I won't be as nice the next time I get one of these filings.
Okay, if the court wants me to file appearance on all these cases and change the pleadings with regards to who lives there and who doesn't, Judge, Judge, I'll be more than happy to do that. I will.
Well, you represented Mr. Davis the entire time, supposedly, because your original appearance was for the occupant, which was Mr. Davis. It was not Ms. Miller. She was not a party. And because she was not a occupant in this property. You represented Mr. Davis. You could have filed your bond as it relates to Mr. Davis, or an appeal as it relates to Mr. Davis. That's not what you did.
Judge, I hear you, Judge. I do. I could amend all those pleadings if you want.
No, we're not going to play that game, because you're just like Mr. Turnwall said. He's been an attorney for was it 3 decades? I think that you have been an attorney probably a comparable amount of time. And you're well experienced. So I think you knew that if you were representing him, then you can appeal for him. That's why you had Ms. Miller file improper. That's my personal opinion. I 100% believe that you are trying to play a game as it relates to who filed what pleadings. Because even if the clerk's office inadvertently removed you as a party, they have to put you back on, because you always represented the occupant, Mr. Davis. At least that's what your appearance stated, so that you could file any motions as it relates to your client. But that's not what we got here. We got something from Ms. Miller. We got multiple filings from Ms. Miller. Then you appeared. That's not appropriate. Again, the position of the court has and will be, if you get an order from another court, whether that be the circuit court or the court of appeals, that tells this court that they need to stop any liquidation of the property because of a pending action in their court that would affect the liquidation, this court will follow that order. But that's not what we have. You're trying to attach someone to this case who's not supposed to be attached to this case to get that order outside of doing it the appropriate way. So for that reason, the motion of reconsideration is denied.
Yeah, Your Honor,
Yes.
will the court give me an opportunity to go to the circuit court to request an order that would be appropriate for this court to consider with regards to the current occupants of the property?
We gave you opportunity since September. What are you talking about? Mr. Turnwell argued multiple times that you need something from the circuit court that would stop this. You never brought it.
No, Judge, no, not from the circuit court with regards to the circuit court case, but the circuit court appeal that was just filed. And with regards to the circuit court, the circuit court
you're talking
appeal,
about
Judge,
the appeal from, you're talking about the appeal of this case by Ms. Miller?
That's correct.
Mr.
Well,
Davis,
yes.
Mr. Davis has to appeal. Ms. Miller is not a party.
Judge, and that's why I said we will amend all those if the court will allow us to, because and I know you don't want to hear my argument anymore, but I think you know my argument, and I just want to make sure, and I know the court understands our position is a distinction without difference. However, saying that, if the court wants me to
The court didn't hear anything you said because the Polycom times out after we've been on here for so many hours, and apparently we've been on here for over 9 hours, so it booted us out. So you need to restate your statements.
Well, what I said to the court is, if the court wants me to redo the captions of the pleadings with the circuit court appeal, that would include all the parties, will be more than happy to do so. I understand
the court doesn't want you to do anything. The court's just telling you that as you filed it, it's being denied. No, I don't want you to do anything. I want you to do whatever you feel is necessary to zealously advocate for your client, so long as it comports with the law and the court rules. That's all I want you to do. And I also want for you not to tie up my docket with matters that are not appropriately filed. That's all I want.
And Judge, I agree with you wholeheartedly.
Your Honor, we'd like the writ to issue. The occupants have not appealed. There is no proper appeal from this case. Appeal in this file. Betty Miller's court ruled is not a party. No bond has been posted. There's $5,600 in arrears. We'd ask the court to issue the writ immediately.
$5,600 is the arrears for the escrow?
For the existing escrow order in district court.
Judge, I don't know how it could be that high. They've made, my understanding, they've made the payments, except for maybe a couple of them. And the order was just entered.
In our motion, we itemized. I can read the itemization into the record.
Please.
October 2023, 1,000 was paid, 1,600 owed. Efficiency 600. November 1,000 paid, 1,600 owed. Efficiency 600. December 1,000 paid, 1,600 owed. Deficiency 600. January 1,000 paid, 1,600 owed. Deficiency 600. February nothing paid. March nothing paid. That as of March today.
Okay, and your dispute, of course, Mr. Turnwell, is that your belief or your client's belief is that the escrow amount was supposed to be 1,000 and not 1,600?
The escrow amount was supposed to be 1,600 based upon our motion for reconsideration that was granted and entered in December 19th, 2000.
Well, I mean, not to interrupt, but Judge, that's the order that you said.
Give me a moment. Give me a moment,
okay.
Sir.
I'm sorry.
When it was changed. No. Yeah, it's to say when it was changed. Let's see.
I have the order, Your Honor.
You have a copy of the signed order?
Yes, I do. It was just here in judgment. We made it as here's the one that Your Honor changed to immediate writ because it may approach.
You may. December 19th.
There's a motion for reconsideration of the existing order. It was granted.
Just in February. Yeah, for some reason, the civil department has it as $1,000.
Well, Judge, let me tell you why. Because when we were at the last hearing, and we can, obviously, this is my recollection, as you said, disregard that order.
It's not true at all. It's not on the record. And we even had to play back some of the Zoom record to Mr. Fair.
You're talking about this hearing was here January 31st, correct?
The trial was January 31st.
Right. And
During
that's
the
when
trial.
This is the date that I signed this. That's the date that I signed this. It's date stamped January 31st.
Because you changed the existing order. You said the existing order shouldn't have the immediate writ portion. That was entered under the 7-day rule. And you pointed out that Mr. Fair should have noticed it. And you crossed out the writ portion, but you left the $1,600 a month reconsideration order intact. I then had discussion with Mr. Fair after the trial, actually had it with my secretary, and informed him that what the existing escrow funds were. He knows all about it.
Well, no, Judge, Judge, the only thing I can say is this whole issue of $1,600, where he's made reference to the 600, 600, and 600, the court didn't enter this order until the 31st.
It was a motion for reconsideration.
Okay. My notes said on November 21st, 2023, I granted the motion. It said the defendant failed to appear. And that I amended the escrow to $1,600, and I lifted the stay of eviction due to defendant not filing with the circuit court for a stay. And so I granted their amendment to the escrow. That's when you were supposed to submit the order under the 7-day rule. So I see where this was filed. And let's see here. We amended it to December 19th being the date on here. That's
the writ portion was amended on December.
Correct. I see that here because we did have a hearing on December 19th. And I crossed out the November on here, put December on there. And then date stamped, I guess, when I further amended at the next court date on January 31st. I date stamped it and signed it for January 31st, crossing out the writ and eviction shall be issued within 10 days. So I do see that, but it does say here that was not crossed out. You were here, sir, on January 31st. You were aware of this order, and it says that the escrow was changed from 1,000 to 1,600. It says that on here. So what is your argument? Your argument is about how many months back we're going to go on that? Is that your question?
Yeah, well, that number one, Judge, and I can tell you your clerk's office is saying it's $1,000.
The clerk's office made a mistake. My order, the court speaks through orders and not clerk's offices. Right,
and I agree with that, Judge. But my client is attempting to balance, I guess the best way to describe it, between going to the clerk's office and being told one thing and the order saying something else. But having said that, it's not $5,600. It is at most March, and my clients will bring that current, whatever the court says that is, forthwith. But it's not $5,600.
You mean it's at most March? What does that mean?
Well, I don't have a copy of when escrow payments were made. But the only point I'm making is if the court is saying that as of January 31st is $1,600, then that means in February, my client has to start paying $1,600. And whatever the court
from December.
Okay, Judge,
this is the order from December. So that means January, February, March, you would have paid $1,600.
And Judge, whatever the court decides today of what the arrears is, it is. And I will ask my clients to to make that payment. Best I can say forthwith. If you give them 10 days, I know they can get it in by then. Because of this unclarity of exactly how much the escrow is, but it's not $5,600. That's the point I'm making.
Well, it's not that I think that the escrow amount was always clear based on the order, and you represented Mr. Davis, so you got that order. You even addressed the court at the next court date about the concern with regard to the writ being issued within 10 days of the order. That's the only thing you addressed, though. We didn't address that escrow, or that was not crossed out at that time. The only thing I addressed on that, so you were aware of the order under the 7-day rule on that escrow being amended from 1,000 to 1,600. I can't speak to why the clerk's office did what the clerk's office did, but we'll make sure that's addressed. I would take the position that at the bare minimum, there should have been a $1,600 payment February and March, though.
Okay, Judge,
Your client's raising his hand. Did you want him to say what he needs to say on the record?
Okay, all right, Judge. Okay, he can say what he wants to say.
You have something you want to say, Keith?
I
Mr.
do owe
Davis?
February and March 1,600. That is correct. I did receive something on it. The problem I have is I was sued for 11,000 in rent, so I don't know when those are or what that is. So
Okay, you were sued for 11,000
for back rent.
for back rent and for a money judgment. Is that what you're suing him for?
Yes, Your Honor, from
That's why I
May
was confused on where to
until
pay it.
October.
And who's that before?
It was for Your Honor. He never answered the pleadings. The default he was issued.
There was a
Issued
default.
the
My son had
complaint,
passed away. I
summons,
missed it.
default happened, you missed.
Did you file a
We then
motion to
had a
set aside
debtor-
the default?
No, Your Honor. We then had a debtor's exam.
I didn't.
The debtor's exam
Judge-
is scheduled this week, Your Honor. It's
Yeah,
the second one.
Judge, I just found out about it. And when I talked to my client about it, he thought that this was part of the same case. And he was wrong, Judge. And I just
That's
found
not
out
true
about
at all.
it. But
He's appeared
no,
at
no,
the
let
debtor's.
me
He
finish.
appeared at the debtor's exam?
Yes.
A few days ago, yes.
Okay,
And they got
But Judge,
moved to the point. I was
I
confused.
just-
yes.
okay.
I can file a motion to set aside the default judgment. And what's the point? The point is the plaintiff is in effect double dipping. On the one hand, he's
That's
asking for
absolutely
writ,
not
and
true
the other
again.
hand, he's asking for escrow.
Okay, well, you should file your motion, please. You're representing him, so you need to file the motion. And if you have an attorney, when you get stuff in the mail, why are you confused? You call your attorney and tell him I got this in the mail.
Your Honor, that wasn't his fault or
No, that's your fault for not
My
calling your
son
attorney
passed away and I
when you got
missed
something.
everything. He passed November 9th.
I'm sorry to hear that.
And I know that's no excuse for anything. My
The
mental-
default is 3 or 4 months old. It's already too late to file a motion to set aside. The debtor's exam.
No,
The first.
No, it's
scheduled
not.
If
up-
I owe the money, Your Honor, I owe the money. I mean, that's
You missed-
fine. I
this is
told
from
Mr.
May.
Kirk-
Okay, what's going on in here?
It's from May until October.
Okay, if that's up to Mr. Fair, if he wants to file a motion for his client to set aside the default, then the court will make a determination after said motion. We're not going to tell him he can't file a motion. He can do that if he wants. You talk to your client as it relates, or to your attorney as it relates to that. I don't know what's being sought in that judgment. I couldn't speak to that. But your attorney will file any necessary motions as it relates to that. We're going to deal with this matter. You agreed that you owe February and March for your escrow, correct?
Yes, ma'am.
He's not disputing that. The itemizations that you're bringing, I think, go back to October, though.
That's when the original order for escrow was entered, and this was a motion for reconsideration.
But
Of
he
that
paid
original order.
$1,000 and
Yeah, and I asked the court, and the court agreed in November, the rent should actually be 1,600 at least.
I get that. If I made you believe that it was my intention to retroactively,
It was a motion for reconsideration, is why I considered it.
I recall that, but my understanding is that I did not go back and reconsider the past amount. Moving forward, I will increase it. I will not go back and
Even then,
make
Your
them
Honor,
pay $600 for months that had passed.
Even then, the order was agreed to entered in November.
I recognize that. Well, my record said it was entered in December.
Okay, with the actual finally got signed in mid-December. So it's at least December, January, February, March.
Well, I agree
So
with the court, Judge.
He hasn't paid anything in March?
No.
Okay, so he owes 600 from January, 600 in February, and then 1,600.
In my opinion, a minimum 1,600 December when the order was signed, January 600, February and March 1,600 each. So now we're at.
I'm not gonna order December because I think I signed it December 19th.
Then there's January 600.
January 600, February 600, and
February
1,600.
1,600. March 1,600. So we're at, I can't add.
Well, he paid something in February, no? Oh, you didn't pay anything in February. I thought you said he paid 1,000. Okay.
3,800. But I'd ask the court to issue the writ immediately. It doesn't mean we have to act on it. But no party in interest appealed this case. Only Betty Miller. I mean, that's very clear by the court filing. So where is the stay? What is the reason for the stay? 10 days from judgment, and the judgment was entered February 2024.
But, Judge, I don't want to.
No appeal has been it.
Judge,
we're a charade,
back
the whole
over
thing.
what we've talked about before.
Okay.
And
I've already entered or stated what my ruling was. Any further banter is just between the two of you all. You all can get each other's phone numbers and knock each other out if you want to go back and forth. I don't need to be here for that. I don't need to be a party. I'm positive that you're going to put in a request for a writ. I'm positive Mr. Fair is going to go and file a motion to stay the writ and then file another filing. I'm positive that we're not done yet. I'm positive of that. But nonetheless, as it relates for today, there will be a order for a writ to issue. And I will note on the record that the bond appeal, let me find this motion to reconsider. Motion to reconsider the bond appeal is denied as Betty Miller is not an appropriate party in this matter. And can you provide an order for that?
Okay.
Okay.
And Judge,
Under the 7-day rule.
Under the 7-day rule, and my understanding, Judge, that you're giving us an opportunity to clean up what needs to be cleaned up. I guess that's the best way to describe it. Because what will happen is that Mr. Davis will file the motion for reconsideration for the $600.
Like I said, I can't stop people I can't prevent anybody from using the court for what the court is here for. And so if proper motions are filed, the court will address them. I can't prevent that.
Your Honor, to be clear, the motion to strike is granted. Betty Miller's name is removed from all the pleadings.
Correct.
The motion for reconsideration is also struck.
No, Judge, you haven't.
The escrow order should reflect that $3,800 are in arrears and need to be paid immediately, and also the bond. So the bond stays the same at $5,000. And Betty Miller is the only party appealing, and non-party appealing. And we've already filed a motion to dismiss in circuit court for that nonsense.
Okay, Judge, the motion to strike, I have not had an opportunity to respond to the motion to strike because you said we're only dealing with the motion for reconsideration. She shouldn't be struck.
I addressed the motion to strike. I granted it today. I don't know where I said it on the record. Well, you wouldn't have him. Why would you need to respond to the motion to strike when you weren't representing her? I'm not following.
Well, Judge, I put in the motion to strike that I was representing all the parties. But having said that, if that's the court's ruling, that's the court's ruling.
Okay, so again, I've stated that the motion to strike was granted. Again, the bond amount or the reconsideration on the bond is denied. I'm going to get an order under the 7-day rule, and then we'll see Mr. Fair's next filing, and the writ shall issue immediately.
The writ shall issue immediately?
Correct.
Judge, you're not going to give us an opportunity to clean up what the court believes to be cleaned up before a writ actually files, because if they're
What the
evicted.
court needs, the court doesn't need to clean up anything. That's you who needs to clean it up.
No, and I agree with that, Judge. But the point of it is, are you going to have them evicted in the interim?
This matter has been pending for I don't know how long. If you want to go and file something, you know how to file a motion to stay a writ.
Yes, I will file a motion to stay the writ, Judge.
Thank you.
Thanks, Your Honor.